Your Honour, I agree with my learned friend that my client's statements to the police are sufficiently relevant according to the rule in Goldsmith and Sandilands, and I make no further submissions on that point. Although my client's statements are prima facie admissible, Your Honour has the discretion to exclude them on public policy grounds, and it's my respectful submission that Your Honour ought to exercise that discretion to prevent my client from being at risk of improper conviction. While there is no rule of evidence precluding evidence obtained illegally from being admitted, I ask that the court consider the illegal and unethical actions of the police in obtaining the statements in question from my client. The Police Powers and Responsibilities Act provides in section 421 that officers must not question children without first allowing the child an opportunity to select a support person and to converse with the support person in circumstances where they're free to speak without being overheard. Your Honour, my client was questioned immediately and without anyone present at the police, let alone a trusted friend or supporter. This is a hugely intimidating circumstance for a child of 14 to be placed in. Any admissions she made must be considered in light of that stressful and overwhelming situation. The police officers at the scene were well aware that my client was not an adult and should have been aware of their responsibilities under the relevant act. Their conduct was not only a contravention of the Act, it was also improper and untoward. When my client was provided with a support person, he was not known to her and certainly was not chosen by her. This shows a clear and unacceptable breach of her rights as a child under the Police Powers and Responsibilities Act. The officers ought to have been aware of the provision and not conducted any interview with my client until and unless a properly appointed support person could be found. The principles from Bunnings and Cross suggest that Your Honour ought to weigh two considerations when deciding whether to exclude this prejudicial evidence on public policy grounds, that is, the social and judicial interest in convicting wrongdoers against the discouraging of police officers from breaking the law. The conduct of the police officers in questioning my client without the presence of a support person seemed to arise from genuine mistake rather than a deliberate breach of the law. This leads Your Honour to consider the cogency of the evidence in question. Although the admissions made by my client in the initial conversation on the day of her detention were persuasive, I respectfully direct the court to consider the decision in the Queen and Day and Another in 2008. The learned judges in that case exercised the discretion to exclude evidence obtained in similar circumstances to those of my client because of the unlawful way the evidence was obtained. I submit that this goes in my client's favour in establishing that the evidence of her initial conversation with the police and the subsequent formal interview ought to be excluded. There were no pressing circumstances forcing the police officers to interview my client without the proper arrangements. There was no physical evidence on the verge of destruction, no risk of Lynn absconding, and certainly no reason to ignore the provisions which were intended to protect children from being pressured into making admissions, which may not be accurate and go firmly against their interests. Bunnings and Cross established that the court ought to consider these factors in conjunction with all the other circumstances in deciding whether to exclude the evidence. The charges against my client, with the exception of arson, which I take the opportunity to point out that there is no evidence she committed beyond her tenuous admission, are not serious. I ask Your Honour to consider whether there is much utility in admitting weak and illegally obtained evidence to the court to convict a child of minor property offences at the expense of encouraging police officers to flout the law. The Bunnings and Cross factors which inform the decision to exercise the discretion, all in my submission, point to the conclusion that the evidence ought to be excluded. I draw Your Honour's attention to section 420 of the Police Powers and Responsibilities Act, referring to questioning Aboriginal and Torres Strait Islander people. While this section doesn't strictly apply to my client's case because of its application only to adults, I respectfully ask Your Honour to consider that in the circumstances, the same cultural and linguistic issues that would affect an adult being questioned by the police are likely to be present and also amplified by virtue of my client's youth. Gratuitous concurrence with questions posed by authority figures is a significant element to be aware of in examining supposed confessions by Aboriginal defendants. My client agreed with the police when she was asked leading questions, causing her to appear to confess when in fact she may simply have been concurring out of cultural and linguistic confusion. Purcell and Bernardos showed us that this is a common issue in questioning Aboriginal children, not just adults. The Queen and Casey illustrates circumstances in which police officers inappropriately interviewed an Aboriginal defendant, leading to admissions, and the court exercised its discretion to exclude that evidence. While this case dealt with an adult defendant and with Section 420 of the Police Powers and Responsibilities Act, it is highly relevant to the issues presented in my client's case. The learned judge in Casey accepted that the statements made against Casey's interests were likely caused by the police officer's failure to comply with the law, and the circumstances of Lynn's admissions are substantially the same. The phenomenon of gratuitous concurrence, as the learned judge named it, appears not to have been considered at all by the police officers questioning my client, and their complete failure to provide an opportunity for an appropriate support person resulted in her being likely unable to understand her rights and responsibilities. In Casey, the learned judge excluded the defendant's statements despite her alleged offences being much more serious than my client's, on public policy grounds. I submit the lack of understanding of the correct manner to question an Aboriginal child is of serious concern in terms of public policy and goes to my client's case that evidence here should be excluded. In summation, Your Honour, I ask that the evidence of my client's admissions in interview with the police be excluded on grounds of public policy. This is so because to include them would be to encourage police officers to ignore their legislated responsibilities to interview children safely and fairly. My client deserved fairer treatment at the hands of the police, and I beg Your Honour to agree that other children in similar circumstances must be protected from the same lack of care. I have no further submissions, Your Honour. Thank you.